have this distinct honor of introducing our lunch speaker today, Drucilla S. Ramey. Drew is a force in hat and heels. She, I am sure, sprang from her mother fighting for civil rights. Every job she has had as a lawyer has involved fighting for the rights of the downtrodden. She started with the Mexican-American Legal Defense Fund. She spent years with the Bar Association of San Francisco. And in those years, she shaped the legal profession in a way that opens doors for disadvantaged people. She found ways to get lawyers to pay for pathways to access to disadvantaged high school students. She has a wonderful and unique way of looking at you, sort of tipping her head down and staring from under the frame of her hat, that makes you realize you can do more and you can give more. And she's used that to help every disadvantaged group, both in the law and coming into the law. She has yards of recognitions. Perhaps the most important of them is the Margaret Brent Award, which is given to several female lawyers annually, recognizing the achievements of women in the profession. When Drew's Margaret Brent Award was announced, she got a handwritten note from one of her law school classmates. Warmest congratulations, love, Hillary.
Oh.
Impressive.
Wow.
And now I'll let Drew talk to you and tell you what more you can do for the profession.
Invited to address you here today. This distinguished group of lawyers, I want to thank Maggie for that kind introduction. She's a magnificent attorney and a very long-time friend, and I want to thank your wonderful executive director, Teresa Hurley, and your bar president, Alva Harding, for this kind invitation to speak. You know, delivering this speech at a time when so many of us are searching for a way to extend hands across some very murky waters while still remaining faithful to our most deeply held principles. Reminds me of my late mother, a medical school endocrinology professor who became a national feminist speaker. She was a very knowledgeable, funny, and relevant to this particular story, very beautiful woman. Anyhow, she was giving one of her trademark kind of bomb thrower speeches at the Fourth Circuit Judicial Conference along the lines of, well, now testosterone isn't a bad hormone, and, you know, a lot of households shouldn't be without it, but estrogen now, there is a hormone. So anyway, after the speech, for which she always demanded and got top dollar and donated it to her Foundation for Older Women Returning to Medicine, after the speech, she was seated at dinner at Chief Justice Rehnquist's table, where he, of course, was surrounded by the usual bevy of sycophantic lawyers and judges. And he lights up a cigarette, and my mother was really just deaf cigarette smokers. And so she looks at him and she says, just put out the cigarette. And, you know, all of these guys kind of shriek back. And so Rehnquist says, well, I'm trying to quit. I mean, I'm down to five cigarettes a day, and she said, well, you know, it's going to kill you anyhow, but then this is quintessentially my mother. She said, did you know? And she said, leaning forward toward him, I wouldn't mind if Jesse Helms smoked. Whereupon he compulsively asked her to dance throughout the rest of the evening. So, getting down to cases prior to the events of November 8th, I know many of you were bracing yourselves to endure the required, but let's face it, not entirely popular units with some, on ethics and diversity, to be delivered to you at lunch here today. But as it happens, events have conspired to catapult what might have been perhaps a quotidian, albeit I would like to say maybe funny at times, exegesis on the intersectionality of ethics and diversity. Instead, in the space of 10 days, these issues have been catapulted to the very apex of our concerns, as a nation and as a profession. concerns about our ability to come to grips with what is fast becoming the measure of our soul, about attitudes and conduct that are contrary to the fundamental principle we all hold so dear, that all people are created equal and all are equal under the law. For the truth is, as headlined by the Washington Post not long ago, law is the least diverse profession in the nation. We make dentists look good. And the Post headline went on to blare that lawyers are not doing enough to change that. But in my brief words to you today, it's really going to be all about how lawyers are, if a bit late to the party, finally starting to do something about it. The dismal fact that we are finally facing up to is that despite the indefatigable efforts of a great many determined individuals and organizations like this distinguished Bar Association, not to say countless sessions on implicit bias, work-life balance, and as one pundit put it, endless Pinot Grigio-infused women's caucus meetings, there continue to multiply an already enormous number of studies that irrefutably establish that the law continues to be a decidedly and in many respects increasingly segregated profession, as to gender, as to race and ethnicity, as to LGBTQ lawyers, and as to lawyers with disabilities. From the richest firms in some of the biggest cities in the world to small firms in Martinez and Contra, right here in Contra, Costa County. A few bald numbers tell the tale. 88% of lawyers in the United States are white, 65% are male, while under 2% are LGBTQ, and barely a third of 1% of all partners in this country are lawyers with disabilities. Now, the fact is, this latter number may be grossly understated, since most men I know will not admit that they have a disability if they're being carried out feet first. But just a couple of salient statistics. While long-standing at over 40% of associates at most large firms and most mid-sized and small firms as well, women equity partners continue to stagnate between 17 and 18%, having barely moved 2 percentage points in the last decade. And according to Major Lindsay and Africa's latest well-publicized study, big firm women equity partners pull in on the average 44% less than their male counterparts. Reminding one, of course, of that great New Yorker cartoon where a slightly hammered guy is in the bar saying to the bartender, "I feel like a man trapped in a woman's salary." And minority partners languish at about the levels that were set 30 years ago by the Bar Association of San Francisco, by people like Maggie Grover, as realizable goals for the year 1995. That is at about 5 to 6%. While African American lawyers as a whole constitute about 3% of all of the lawyers in big law. And that is likely to fall in light of the current trends in our profession, including the increasing sort of mega firm merger phenomenon with Arnold and Porter, Case-Shoulder mergers among the most recent. The increasing recourse of large firms to white male lateral pools to fill their equity partner ranks is another major phenomenon. And of course, we have the increasing multi-continental Swiss Verein movement, which have been described by some legal commentators as legal friends with benefits, which are 3,000 or 4,000 lawyer firms like DLA Piper and Norton Rose Fulbright, and they do not bode well for already marginalized groups, and they do not bode well, incidentally, I might say, for financial or pro bono generosity to local groups that are dedicated to the kind of work that so many groups here in this county do. And nor can we realistically expect to be saved by the pipeline in law schools, in large part owing to the highly successful attacks on affirmative action, beginning with California's own Proposition 209. ABA statistics show that while the percentage of minority law students, largely dominated at that time by both African American and Mexican Americans, as well as Asian American students, that while that percentage more than tripled between 1971 and 1996, the passage of Proposition 209, from 6% to 20%, it has risen a pitiable 6% in the 20 years after that. And virtually all of that increase is due to a couple of Asian groups and to Cuban Americans, Mexican Americans and African Americans, as well as Native Americans, are becoming an increasingly vanishing breed in our profession. Meanwhile, of course, the very substantially larger group of alumni legacy admittees to the elite schools that feed our law schools continues to flourish unabated. For example, 42% or so of all of the children of Harvard alums who apply get in versus 3 to 4% of everybody else. And these overwhelmingly white students are a group whose stats were found by the Bush II administration, of all things, to be at about the levels of the preferentially admitted athletes. That great legal scholar, Al Franken, in his book, Rush Limbaugh is a Big Fat Idiot, and may I digress here to note that Mr. Limbaugh's most recent contribution to the lexicon is the statement that who in this country would really want to watch a woman get older before their very eyes on a daily basis. Anyhow, Al Franken, back in his funny days, best captured the legacy admit phenomenon as follows. He said, I'd like to speak to an affirmative action program, which, as a Harvard graduate, I do like, he said, and that is affirmative action for the children of Ivy League grads. He says, there's all kinds of good reasons for this. Well, one, really, money. But as it stands, it's an affirmative action program for one of the most privileged groups in this country, the sons and daughters of people like me. He then goes on to observe, now he says, we're told that one of the pernicious and poisonous unintended consequences of affirmative action is that it taints the very real accomplishments of qualified blacks who have earned their place at the table. But you know, he says, all the time I was at Harvard, I never once heard a Lowell or a Cabot remark, I dare say, I despise this god-awful legacy policy. It makes me so suspect in the eyes of my classmates. So back to basics. The truth is that virtually every single one of the hundreds of studies that have been performed about the shameful lack of diversity in our profession, especially at the top, has demonstrated that one of the primary factors driving these patterns of exclusion is a shamefully high level of prejudice and bias. Now, some of this is, to be sure, the so-called implicit bias we've all been hearing so much about, based on largely unconscious, destructive stereotypes, and more about that later. But right now, let us not forget the words of a chair of a very large and highly prestigious law firm who told me, you know, we really don't have to worry all that much about implicit bias here at the firm. He said, because we have so much explicit bias here. In any event, study after study demonstrates that harassment, bias, and prejudice at whatever level of consciousness pervades our profession, with few, if any, adverse consequences accruing to the purse. Just to throw out a few examples, and these are examples that were collected by the San Francisco Bar in our many studies. The tenured faculty member, a former dean no less, of a distinguished law school hiring committee saying a highly distinguished Japanese-American faculty candidate, well, hell, are we just going to take any Sony off the shelf? Or the powerful white male partner who tells a pregnant junior partner, look, you either run with the nannies or you run with the wolves. Or, and I take this one personally, the woman partner who's told, we can't put a short woman on this case, the client won't think we're serious. Or the Chinese-American woman who's told she can't be the second chair on a major matter because she's just too nice. Fortunately, she landed the position when another senior colleague told the guy that she really wasn't very nice at all. Or white partners who can't distinguish among their black colleagues who look nothing alike, nor between them and the Xerox machine operator. Frankly, it is no wonder then that a highly successful African-American lawyer like Eva Patterson wears a t-shirt that says, of course I'm tired, I've been black all day. And exists there a woman in this room today who has not endured the famous, say, I got a joke for you routine? My mother, I must say, had one of the better ripostes for that situation. So a new professor comes into the department at Georgetown Medical School, and he says, I heard about you, you're the feminist. And she said, yes, and you are. And he says, Dr. Jones, and he says, I got a good joke for you. And so the other guys in the department say, don't do it. You will regret it. And he says, no, go right ahead, Dr. Jones. So he says, okay, how are women like statistics? And she says, I don't know, Dr. Jones. How are women like statistics? And he says, because once you get them down, you can do anything you want with them. And he looks at her and he says, what's the matter? No sense of humor? So she says, well, you know, Dr. Jones, I took some psychiatry in my training, and you know, the professor said you can tell a lot about a man's mother by the kind of jokes he tells. And she said, judging from the joke you just told, I'd have to assume your mother was a whore. And you know, he had no sense of humor. And so he says to her, you know, if you were a man, I'd hit you. And she said, well, if you were a man, I'd hit you. Now, our own profession, of course, reflects that age-old reality that makes it hard for a woman to pull that kind of thing at her own law firm. And that is, as one pundit once put it, a man has to be an ex-murderer to be called ruthless, while all a woman has to do is put you on hold. Now, of course, it's no wonder that the incredibly smart women feel constrained from forcefully expressing their views and opinions at work. The Daily Show's Jon Stewart, you may recall, once accused Gretchen Carlson, the woman who outed Roger Ailes, who was herself a Stanford and Oxford graduate, of stashing her IQ in an offshore account in the Cayman Islands in order to make it at Fox News. But she had enough brain power to carry a tape recorder on her person, didn't she? You know, in my 120 years as executive director and general counsel of San Francisco Bar, if there is one thing that I learned, it is that if you want to attack these profound patterns of bias and discrimination and achieve true diversity in our firms and our profession, it really has to come from the top, from the people sitting here in this room and your fellow judicial and legal colleagues in California and across the country. Since November 8th, as I earlier stated, we head into some exceptionally stormy seas ahead. Never has the achievement of true diversity and elimination of discrimination in the judiciary and legal profession been of more importance to this nation's soul and its productivity. Putting aside for a minute the increasingly compelling case for legal diversity in our global economy, some of the best articulated broader rationales have emanated from Supreme Court justices in their evaluation of the towering importance of Justice Thurgood Marshall's decades on the court. In noting that his own unique background and experiences as an African-American man informed not only his own judicial perspective, but that of his white colleagues, Justice Sandra Day O'Connor observed, quote, Justice Marshall imparted not only his legal acumen, but also his life experiences, constantly pushing and prodding his colleagues to respond not only to the persuasiveness of legal argument, but also to the power of moral truth. And Justice Byron White, not exactly a red-hot liberal, acknowledged Justice Marshall's uniquely powerful influence on equal justice. Justice Marshall, he said, would tell us things that we knew but would rather forget. And he told us much that we did not know due to the limitations of our own experience. Yet even putting aside social justice issues, America's most powerful legal institutions not only continue to lose these diversity of background advantages brought to decision-making by averaging 2 women or fewer in the management committees and the compensation committees of most firms, but they also forego the advantages as demonstrated by numerous studies that firms and corporations with more diversity at the top are far more diverse throughout and are more profitable. We now know, of course, a lot more than we used to about what steers and what inhibits both expressly and implicitly biased behavior. Numerous studies have demonstrated, for example, that this kind of misconduct can be prevented, ameliorated, or remedied by so-called bias interrupters, as the lingo goes. And these interrupters include, of course, the kind of implicit bias training many of you have undergone, designed, of course, to make us more conscious of and to take some concrete actions to avoid and address the effects of conduct that has been so exhaustively documented as perhaps unconscious. First is the tendency in employment decision to systematically prefer members of socially privileged groups. That is white versus black, able versus disabled, straight versus gay, male versus female, and so on. And second, and to my own acute discomfort, we know that people who rate themselves as most objective and neutral on these issues, on tests like the Harvard IAT test, which has been taken by over 2 million people, those folks actually turn out to be much more likely to act on their own discriminatory preferences for whites and for men and so on. And worse still, in a society and a profession which prides themselves on being monuments to merit, we in fact systematically redefine merit to justify our own discriminatory decisions. My own personal favorite of these kinds of studies was a famous study in which participants were asked to evaluate the paper credentials of a male versus female candidate for police chief. The leading strengths of one of the two candidates, either the man or the woman, focused on a formal education with high-level administrative skills, good with the media, etc. While the leading strengths of the other candidate, male or female, focused on streetwise cred, tough, risk-taking, experience from rough neighborhoods, and so forth, but not much education and a poor administrator. In the study, these profiles were randomly assigned to male and female candidates, regardless of which set of competencies, the educated versus streetwise, was featured as his primary strength. The male candidate was consistently favored by study participants who redefined the criteria for success on the job as requiring the specific credentials that the male candidate happened to have. And of course, the ABA itself performed the most famous study of the legal profession, whereby a group of 60 law firm partners were given the same purported third-year associate memo, one purportedly by an African-American male and one by a white male. Not only were the scores substantially lower for the purportedly black-authored memo, but the comments were widely divergent as well. Good analytic skills has some real potential for the purportedly white memo versus needs lots of work and I can't even believe he went to NYU Law School for the black. As to women, these, of course, phenomenon are exacerbated by the well-documented tendency on the part of women to undervalue their own worth and attribute their loss of a hire, a promotion, a salary, whatever, to the assumption that they're just not as good. Better they should, of course, follow the sage advice of one pundit who said, before you diagnose yourself with depression or low self-esteem, first make sure you are not, in fact, just surrounded by assholes. These phenomena play out specifically in the legal profession by way of a group of almost entirely white, straight, at least publicly, men who overwhelmingly populate the all-powerful management and compensation committees that directly or indirectly dole out everything from jobs to home assignments to evaluations to promotions to partnerships and, of course, to that all-important issue, billing credit. So these people seek out younger versions of themselves, maybe not as good looking, but these homogeneous groups engage in highly subjective decision making on committees that have been characterized by a very prominent management consultant, himself a former general counsel of a Fortune 500 corporation, as, quote, veritable petri dishes of bias, where the level of ignorance and bias is alarming. Calling to mind, at least my mind at least, Molly Iron's great line about a particular Texas lawyer. She said, if ignorance ever goes to $40 a barrel, I want drilling rights on that man's head. It was 30-some odd years ago, with the advent of the minority counsel programs, that the profession inaugurated its first, and until recently, from my perspective, practically its only truly effective kind of bias interrupter. As the old saw puts it, and I'm going to put it in a more ladylike way here, you get them by their paychecks and their hearts and minds will follow. That is, clients insisting in various ways on more diversity in the firms and individuals that they retain. Only a few, however, and I'm sure the State Farm lawyer who is about to become your president is among those, are taking the next, and I would argue most important step, starting the process with some cooperation with an ABA initiative. And that is intruding themselves directly into the all-important firm distribution of client dollars among their lawyers in their retained firms, insisting on diversity among the lawyers performing their work, and insisting that their dollars and the credit for those hours go to the very lawyers who actually lead and perform their work, rather than the so-called origination partners who may have landed that client 45 years ago and will only give it up when they are carried out first. When other major clients joined Walmart, yes, Walmart of all places, the Gap and other pioneering clients in insisting on exercising their rights and responsibilities in this regard, then and only then will the resulting redistribution of wealth within law firms, in fact, jumpstart real progress in diversifying this profession. But just this year, we are seeing the advent of two additional and potentially profession-rocking examples of a different kind of bias interrupter. The first is the coming tsunami, as the AmLaw media people call it, of major pay equity lawsuits and increasingly class actions by women, and I would soon wager minorities, including against firms like Chadbourne Park, Sedgwick, Greenberg Trorg, and Mintz-Levin, just to name a few. And given the wildly subjective manner in which partner compensation is handled in most firms, these suits may be greatly facilitated by last year's passage of the California Fair Pay Act, which for the and this is, because this is supposed to be MCLE, I throw this in, I just want you to know that. The organization I'm lucky enough to chair, Equal Rights Advocates, was the primary mover on that. It is a statute that is spearheaded by a remarkable coalition, a bipartisan coalition, and passed and pushed by Senator Hannah Beth Jackson more than any other. But it was a bipartisan vote with the support of the California Chamber of Commerce, an almost unheard of phenomenon, no less, and signed by Governor Brown at the Rosie the Riveter Museum in your very county. This act is the most far-reaching such statute in the nation, and it is already being replicated in Massachusetts and elsewhere. In a nutshell, under the act, once a plaintiff has proven that she has been paid less than a man in a substantially similar job, as defined in the statute, in any of the employer's work establishments, the burden shifts to the employer to demonstrate that the differential is attributable, putting aside seniority, merit, and piecework systems, to a reasonably applied bona fide factor other than gender that serves an overriding business purpose, and that the entire gap is attributable to that factor, which the employee can then show can be met by a less gender-restrictive alternative. Very importantly, the law also bars retaliation against employees for asking about or revealing or discussing salaries. And if you want to see the impact of people finding out what other people make for the very first time, take a look at some of the lawsuits against law schools lately. Because of the fall off in law students around this country, law schools have had to offer buyouts to some of their most expensive senior faculty. And guess what? Those buyouts are based on current salary. And so for the first time, the entire senior faculty of these law schools are learning what everybody else makes, and the result has been a rash of lawsuits. The second major bias interrupter I would posit that is relevant here is this year's passage by the ABA, albeit more than 50 years after the passage of the Civil Rights Act, of the new model rule of professional conduct 8.4G, which is in the packets that you should have received, and which, subject to hopefully narrowly construed limitations, proscribes lawyers, while engaging in conduct related to the practice of law, from engaging in conduct they know or reasonably should know, and we had to compromise to let that in, is harassment or discriminatory otherwise on the basis of race, gender, and a variety of other characteristics. Now, I personally take it as a point of personal pride, by the way, that Breitbart's own Ed Meese, who I frankly had thought was dead, actually publicly denounced my testimony in support of this rule, along with that of ABA President Paulette Brown's testimony, as both fascist and anti-Christian, which frankly would have surprised my Southern Baptist aunts in Eddyville, Kentucky. Of course, Rule 2.3c, which I know you are intimately familiar with, of the Model Code of Judicial Conduct has for some time now set forth the rules of the road for, not only for judges, but for their responsibility to limit the and prohibit the discriminatory conduct of the lawyers who appear before them. But even without a federal judicial rule to this effect, 2 federal jurors recently imposed sanctions against lawyers who had engaged in discriminatory conduct, with both of them citing a recent ABA study showing the horrifying paucity of women serving as lead counsel in federal actions, with both judges emphasizing the causal link between discriminatory attorney conduct and the persistent lack of gender diversity in the legal profession. One of the judges condemned his unethical statements, including, and I take this one personally too, "You're not getting menopause, I hope," and "Don't raise your voice at me, it's just not becoming a woman," which had been directed by a male lawyer to his female opposing counsel. I should note here that in California, the state bar is being asked to okay a new rule which, while far better than the existing rule, in fact is much too narrow and limits the requirements to conduct which is found to be unlawful, requiring essentially a trial within a trial, and therefore essentially nullifying the rule as far as I'm concerned. And I urge all of you to just pick up those iPhones of yours and let the state bar know how you feel about that. But if lawyers know that they may be subject to sanctions for harassing or otherwise engaging in discriminatory conduct, they will have a strong incentive to not engage in that, and to educate themselves about what that really is and about the injurious impact of their own behavior. There is no time here to get into all of the things that law firms can do, but you know, there are all these corporations that have signed these agreements to do pay audits across the board, and look at all of the publicity, favorable publicity that Salesforce has gotten for doing an audit and paying an additional $3 million a year to take care of some of the gender bias that they found. I mean, is there a single law firm that has agreed to perform such an audit? No, there isn't. But I know there are firms represented here today that want to do just that, and I would urge you to do that. Because as currently structured, the undeniable message in our profession has too often been, you won't make it here. And the well-documented result is that they leave. Hence the recent article on a careerist blog that said, "Dear Mrs. Clooney, don't quit." Almost 20 years ago, Harvard professor David Wilkins wrote of a tragic reality which now more than ever in our profession is something we have to own up to and face up to. He said, "Few would dispute that the campaign to end legal segregation, culminating in Brown versus Board, is the legal profession's finest accomplishment, just as the profession's complicity in the regime that this campaign demolished was its darkest hour. The fact that the country's most prestigious law firms are nearly as segregated today as the entire legal system was 40 years ago stands as a constant rebuke to the profession's attempt to claim the noble side of this heritage. As the legal profession confronts the uncertainties of the next millennium," this was written 20 years ago, not to say the next 4 years, "it is the energy of recent initiatives that hold the best hope for charting a new path that connects the profession's future to the best of its past." And in closing, I want to say that I have found that I and many of my friends, male and female alike, have been focusing on what our mothers or fathers would have had to say about the outcome of the recent election and the profoundly disturbing campaign which preceded it. My mother, like many of your mothers and grandmothers, was born before women had the vote and endured a far more hostile world, I would suggest, than ours, including 2 world wars, the Holocaust, Ronald Reagan, Richard Nixon. I digress. As an impoverished Brooklyn Jew, whose own illiterate mother raised 2 children alone at the height of the Great Depression, she, like so many women of her generation, not only persevered, but triumphed in the face of very extreme adversity, and she counted herself as among the most fortunate of human beings. So I found myself heartened by, and choose to close this, by sharing with you the words of a piece that my mother wrote in her late 70s for a book called Letters to Our Children, a book published by U.S. News and World Report, which frankly is the only good thing that organization ever did. At this stage in my life, she wrote, I don't do much agonizing about mistakes I may have made. It's not the stupid things I did that disturb my sleep. It's the things I didn't do, the words I never spoke, the little kindnesses I omitted because I had my eyes on a goal and I was running so fast to get there. These are my greatest regrets. The most painful memories I have are my mother's pain because she couldn't buy me that special dress for the prom, because I had to work at menial jobs after school, because I had to wear unfashionable cast-offs from the rich aunt. I never told her how unimportant all those things were to me compared to the priceless gifts she had given me of unwavering love and confidence. I thought she knew. And by the time I learned the need for words, there were no longer ears to hear. I learned too late that words can be weapons or they can be life-enhancing. I have in my life received honors and honorary degrees, and every time I stand up there to receive the accolades, I feel my mother's beside me saying, see, Stella, I told you to get an education. And I say at last, thank you for everything you gave me. So if I could leave you with any advice, she concluded, it would be to speak words of caring, not only to those closest to you, but to all the hungry ears you encounter on your journey through a cold world. Stop on that mountain climb to bring along those less agile, less well-endowed. It will make the view even more beautiful when you get to the top. Thank you. She gave this magnificent glitter safety pin. But I simply have to mention that one of the funniest lines I ever saw an ABA person, they're not very funny people for the most part, but the ABA person would say, the guy who was the head of the ABA group that handled bar associations, a wonderful guy gets up there, and he's introducing, and then the guy starts to speak as the keynote speaker, and the guy was dead drunk and passed out right there on the floor. And so this ABA guy says, and now Mr. Smith will take a few questions from the floor.